Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. It is Saturday. I was driving all the way across the state yesterday to the mothership here on the beautiful campus of Washington State University when suddenly news broke that the United States Supreme Court has yet again accepted review of another very, very critical firearms case. We're going to geek out on that a little bit because, as usual, the mainstream media is completely misportraying what this case is all about. So we're going to get truthful today. We're going to get honest. We're going to get right to it. We're going to talk about exactly how important this case really is. So today, let's spend a few minutes. Let's get you all educated and let's talk about the real reason the bump stock case is so huge. Okay, like I said, coming to you from the campus of Washington State University, the mothership, my alma mater. We are talking about the case of Cargill v. Garland. It is a case out of the Fifth Circuit. We have geeked out on the case of Cargill v. Garland before. Why? Well, that was a challenge to the Trump administration's ban on bump stocks. The Fifth Circuit, as you recall, has thrown that ban out. The United States has applied for certiorari to the United States Supreme Court, and the United States Supreme Court yesterday, Friday, November 3rd, announced that they are in fact going to accept review of this case for next year's term. Now, a lot of people think that this case is all about, does bump stocks meet the definition of machine guns as defined in 28 United States Code 5845? But I can assure you that there is a lot more going on, far more important issues. And so for everybody in the mainstream media right now who today is saying that the Supreme Court has accepted a case to determine whether or not machine guns can be lawfully owned, that is absolutely, completely incorrect and the farthest thing from the truth. Now, if you recall, the bump stock ban happened because of a horrific mass shooting. In fact, the largest mass shooting in America's history back in 2017 on the Las Vegas Strip. Now, despite the fact that there was plenty of political pressure and clout at that time and political momentum in which the Trump administration probably could have gone to Congress and probably could have passed legislation to ban bump stocks, Donald Trump did exactly what Joe Biden is doing right now, which is he let the ATF off the leash and told them to ban it. And so the question in Cargill v. Garland is not about whether or not bump stocks should be banned. The question is what is the limitations of the executive branch's reach? As a matter of fact, this case in many ways has absolutely nothing to do with the Second Amendment and everything to do with the separation of powers. Because let us remember that what the Trump administration did, which is no different than what the Biden administration has done on multiple occasions since taking office, is rather than go to Congress and ask them to pass legislation, you know, the way our founding fathers set our country up to be, instead, the executive agency takes its own action and outlaws these items without any type of congressional fiat. And we are seeing this not just with the three-letter agency of the ATF. We see this with the FCC. We see this with the FDA. We see this with the SEC. We see this with the FAA. We see it with every single alphabet agency. And this is a chance for the Supreme Court to once and for all limit what is oftentimes referred to as the fourth branch of government. Now, one of the issues, obviously, that will be up for debate before the Supreme Court will be whether or not bump stocks even fall under the federal definition of machine gun. A federal definition of machine gun actually requires that multiple rounds be discharged per single function of the trigger. But as we know with bump stocks, as well as with forced reset triggers and wide open triggers, the trigger actually does function each and every time that a round is discharged. But beyond this statutory interpretation, this is an opportunity once and for all for the United States Supreme Court to tell the federal government, listen, if you want to change the gun laws, there is a right way to do it and there's a wrong way to do it. And our founding fathers set that system up all the way back when they ratified our Constitution. Now, why else is this case so huge? Let's think about it. Where else has the ATF just decided, sua sponte or with presidential direction, to, hey, let's just change the classification of something in the hopes of outlawing it? Let's take a look at what they did with 80% lowers, or their rule on unfinished frames and receivers. Let's take a look at what they did with firearms with attached stabilizing braces. The ATF okayed those for years. Suddenly, a change in presidential administration. No, now they are federally regulated short barrel rifles. And then, probably most on point, let's take a look at what the ATF did with forced reset triggers, wide open triggers, and the Hellfire triggers. Because the technology which is in argument in those issues is exactly the same as what's going to be argued in the matter of Cargill v. Garland. So the bottom line is that this Supreme Court has finally shown a willingness to accept these very critical issues that deal with our inalienable rights. The court has accepted review on Cargill v. Garland. It will be obviously set on the docket for sometime next term. We will obviously keep you posted. This, as well as many other things that are happening at the United States Supreme Court over the next couple years, are going to once and for all define what your otherwise inalienable rights will be. The case, once again, is Cargill v. Garland. We'll link it up down below so you can geek out on it for yourself. In the meantime, if you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is right down there in the description box as well. In the meantime, let's everyone remember now that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. From the beautiful campus of Washington State University, thanks for watching and stay safe.